The confrontation between Donald Trump and the American judiciary did not simmer quietly behind closed doors. It exploded into public view through courtrooms, fines, historic rulings, and constitutional showdowns that unfolded across 2024 and into 2025. On February 16, 2024, New York State Supreme Court Justice Arthur Engoron ordered Trump to pay $454 million in penalties after ruling that he had fraudulently inflated asset values to secure favorable loans and insurance terms. The judgment barred him from serving as an officer or director of any New York corporation for 3 years and imposed an independent financial monitor over his business operations. This was not symbolic, it was one of the largest civil fraud penalties ever imposed on a former president. Trump immediately attacked the ruling as politically motivated, but the court's 92-page decision laid out detailed financial findings, citing years of misstatements and deceptive valuations tied to properties including Trump Tower and Mar-a-Lago. Just weeks earlier, on January 26, 2024, a federal jury in Manhattan awarded writer E. Jean Carroll $83.3 million in damages in a defamation case presided over by U.S. District Judge Lewis Kaplan. The ruling came after Trump repeatedly attacked Carroll following a prior jury finding that he had sexually abused and defamed her. Judge Kaplan sharply limited Trump's courtroom conduct and warned of consequences if he attempted to relitigate settled findings. The verdict sent a clear signal. Post-trial attacks on accusers could carry enormous financial consequences. Combined with the New York fraud ruling, Trump faced more than $500 million in court-ordered penalties within a single month, an unprecedented legal squeeze for a leading presidential candidate. The tension escalated further during Trump's criminal trial in Manhattan, tied to falsified business records. On April 30, 2024, Justice Juan Merchan fined Trump $9,000 for violating a gag order that prohibited public attacks on witnesses and jurors. The judge found 9 separate violations and warned that continued breaches could result in incarceration. The image of a former president being threatened with jail time for contempt inside a state courtroom was extraordinary. Trump responded publicly, accusing the court of suppressing his speech during an election year. The legal system responded by reaffirming its authority to protect proceedings from intimidation. That collision, free speech claims versus courtroom integrity, became a defining flashpoint. The most sweeping constitutional clash arrived on July 1, 2024, when the Supreme Court of the United States issued its landmark decision in Trump v. United States. In a 6-3 ruling, the court held that presidents possess absolute immunity for official acts and presumptive immunity for other official conduct, while remaining unprotected for purely private actions. The decision forced lower courts to reassess federal criminal charges related to Trump's efforts to challenge the 2020 election results. Supporters framed the ruling as a defense of executive independence. Critics warned it dramatically expanded presidential protections beyond historical precedent. What made the moment seismic was not just the outcome. It was the acknowledgement that a former president's criminal exposure required the highest court to define the outer boundaries of executive power in real time. These rulings, civil fraud penalties, defamation damages, criminal contempt fines, and a historic Supreme Court immunity framework, form the backbone of an escalating institutional battle. Courts have demonstrated a willingness to impose financial punishment, restrict speech inside proceedings, and shape the constitutional limits of presidential authority. Trump, in turn, has responded with appeals, public denunciations, and claims of judicial bias. The legal system has not moved cautiously. It has acted decisively, issuing orders with immediate financial and political consequences. The result is not a theoretical debate about checks and balances. It is a live confrontation between a former president seeking political power and judges asserting the authority of the courts. The collision between Donald Trump and the judiciary did not begin with headline-grabbing fines. It evolved through a chain reaction of legal maneuvers, escalating rhetoric, and courtroom rulings that hardened into a structural standoff between the executive and the courts. After the July 1, 2024 ruling by the Supreme Court of the United States in Trump v. United States, which established that presidents have absolute immunity for official acts and presumptive immunity for related conduct, federal prosecutors were forced to recalibrate their approach to pending election interference charges. The decision did not eliminate prosecution. Instead, it required lower courts to determine which alleged actions qualified as official. That legal gray zone immediately reshaped timelines. Federal District Judge Tanya Chutkan, overseeing the January 6 related federal case in Washington, paused proceedings to allow arguments on how the Supreme Court's immunity framework applied. The pause effectively delayed trial momentum during a heated election cycle, demonstrating how constitutional interpretation can directly affect political calendars. Meanwhile, at the state level in Georgia, Fulton County District Attorney Fani Willis faced her own courtroom scrutiny in early 2024 over alleged conflicts of interest in the racketeering case against Trump and his co-defendants. Defense attorneys sought to disqualify her office, arguing that her personal relationship with a special prosecutor created bias. Although the presiding judge ultimately allowed Willis to remain if certain conditions were met, the hearings exposed vulnerabilities in the prosecution structure and added complexity to an already sprawling RICO case. The Georgia proceedings revealed a parallel truth. While Trump was attacking the legal system publicly, prosecutors themselves were under intense judicial examination. The legal battlefield was not one-sided. Every actor was being tested under procedural fire. Back in New York, following Justice Arthur Engoron's February 2024 civil fraud ruling, Trump's legal team sought to secure a bond to prevent asset seizure while appealing the $454 million judgment. For weeks, headlines focused on whether Trump could post the full bond amount, a requirement under New York law to pause enforcement. In late March 2024, an appellate court reduced the bond requirement to $175 million, granting temporary relief while the appeal proceeds. That appellate intervention illustrated the layered nature of judicial review. Trial courts impose penalties, appellate courts recalibrate risk, and enforcement remains subject to strict procedural rules. It also showed that even amid aggressive rulings, the system maintained structured safeguards rather than instant financial collapse. Simultaneously, the Manhattan criminal trial over falsified business records intensified courtroom tensions. Justice Juan Merchan repeatedly warned Trump against violating gag orders intended to protect jurors and witnesses from intimidation. Each fine, though modest in dollar terms, symbolized judicial authority asserting control over courtroom conduct. The broader implication was unmistakable. Judges were willing to discipline a former president as they would any defendant. The visual contrast, campaign rallies outside, contempt findings inside, underscored the friction between political messaging and judicial procedure. What deepened the standoff was Trump's public framing of these cases as coordinated political attacks. In speeches and social media posts throughout 2024, he characterized judges and prosecutors as partisan actors. The judiciary responded not with public rebuttals but through written orders, structured hearings, and carefully worded opinions rooted in statute and precedent. That asymmetry, rhetoric versus rulings, widened the perception gap among supporters and critics alike. For Trump's base, each indictment reinforced claims of persecution. For the courts, each filing reinforced adherence to established legal process. The pattern is now unmistakable. Trial courts impose penalties, appellate courts refine boundaries. The Supreme Court defines constitutional scope, prosecutors adjust, defense teams appeal, and Trump continues campaigning while entangled in layered litigation across multiple jurisdictions. What began as individual cases has matured into a broader institutional confrontation over executive power, judicial independence, and the limits of immunity. The legal system is not retreating. It is methodically asserting jurisdiction, step by step, ruling by ruling. The legal collision between Donald Trump and the courts is no longer confined to briefs and rulings. It is producing measurable political, economic, and institutional consequences that ripple far beyond the courtroom walls. When a New York jury ordered Trump in January 2024 to pay $83.3 million to E. Jean Carroll for defamation, the financial shock was immediate, but the broader impact was structural. Within weeks, Trump's legal team moved aggressively to secure bonds and restructure liquidity in order to prevent asset seizures tied to the separate $454 million civil fraud judgment imposed in February 2024 by Justice Arthur Engoron. The appeals process required Trump to secure a reduced $175 million bond in March 2024 after an appellate court intervened. but the episode exposed how judicial enforcement mechanisms can directly pressure business operations tied to a former president. Financial institutions, insurers, and contractors tied to Trump properties faced renewed scrutiny, while lenders reassessed exposure risks amid active litigation. Court rulings were no longer abstract, they carried enforceable financial weight. The economic fallout intersected with political momentum during the Manhattan criminal trial overseen by Justice Juan Merchan, which began in April 2024. The trial, centered on falsified business records related to hush money payments, required Trump to sit in a courtroom during an active presidential campaign. Every day in court was a day not spent on the trail. The judge's enforcement of gag orders, including contempt fines issued on April 30, 2024, underscored the judiciary's insistence on procedural control. The image of a former president and active candidate, bound by courtroom restrictions, was unprecedented in modern American politics. It demonstrated that criminal defendants, regardless of office held or sought, remain subject to judicial authority. The most consequential structural shift came on July 1, 2024, when the Supreme Court of the United States ruled in Trump v. United States that presidents have absolute immunity for official acts and presumptive immunity for related conduct. The decision forced federal prosecutors and lower courts to dissect which actions surrounding the 2020 election challenge qualified as official. The ruling did not dismiss charges outright, but it slowed proceedings and required evidentiary reclassification. That delay had real-world effects. Trial timelines shifted, public attention intensified, and the balance between executive power and criminal accountability was recalibrated in real time. Legal scholars immediately recognized the magnitude. The court had drawn a constitutional boundary that future presidents will rely on for decades. Meanwhile, in Georgia, proceedings involving District Attorney Fani Willis added procedural turbulence to the state racketeering case. Defense challenges to her role generated hearings that temporarily threatened prosecutorial continuity. Although she remained in position, the litigation underscored how complex multi-defendant cases can fracture under internal scrutiny. Every motion, every appeal, and every evidentiary ruling adds months to timelines. Justice delayed does not mean justice denied, but it does mean prolonged uncertainty. The human dimension of this legal war is often overlooked. Court staff, jurors, and witnesses in high-profile proceedings have required heightened security measures. Judges have faced public criticism and, in some instances, threats that prompted protective protocols. The judiciary operates on precedent and procedure, but the political temperature surrounding these cases is unusually high. Safeguarding courtroom integrity has required expanded resources and coordination between federal and local authorities. Beyond individual rulings, public trust is now part of the fallout. Polling throughout late 2024 showed sharp partisan divides over whether the prosecutions represented accountability or political targeting. That polarization affects institutional confidence not just in Trump, but in the courts themselves. When half the electorate questions judicial motives and the other half demands aggressive enforcement, the judiciary becomes a central political actor whether it seeks that role or not. The economic, political, and institutional consequences are converging. Financial penalties strain liquidity. Criminal trials reshape campaign schedules. Supreme Court rulings redefine executive immunity. State prosecutions navigate procedural landmines. Security concerns surround court personnel. The legal system is asserting authority, but every assertion carries downstream impact on markets, on elections, and on public confidence. This is no longer just litigation. It is a high-stakes stress test of American democratic infrastructure unfolding in real time. Accountability in this escalating confrontation is no longer theoretical. It is being written into court orders, financial judgments, and constitutional precedent. At the center remains Donald Trump, but the broader clash now includes trial judges, appellate panels, prosecutors, and ultimately the Supreme Court of the United States. The defining turning point came on July 1, 2024, when the Supreme Court ruled in Trump v. United States that a former president enjoys absolute immunity for official acts and presumptive immunity for actions within the outer perimeter of official duties. That 6-3 decision forced lower courts to reevaluate federal criminal charges related to election interference. Critics argued the ruling expanded executive protection beyond historical norms. Supporters said it prevented politically motivated prosecutions from paralyzing future presidents. What is undeniable is that the court fundamentally reshaped the boundaries of presidential criminal exposure, shifting the burden onto trial courts to determine what qualifies as official. That single ruling altered the legal battlefield overnight. At the trial court level, judges have shown no hesitation in enforcing procedural authority. In New York, Justice Arthur Engoron imposed a $454 million civil fraud judgment in February 2024, after concluding that Trump and his company had inflated asset valuations for years. The ruling was detailed, citing documentary evidence and financial statements. Engoron also barred Trump from serving as a corporate officer in New York for 3 years. Trump's legal team responded with appeals, arguing the penalties were excessive and politically driven. In March 2024, a New York appellate court reduced the immediate bond requirement to $175 million while the appeal proceeds, demonstrating that judicial accountability operates through layered review rather than unchecked enforcement. Still, the scale of the penalty sent a clear signal. Courts are prepared to impose historic financial consequences when statutory violations are proven. Meanwhile, Justice Juan Merchan enforced strict courtroom discipline during the Manhattan criminal trial that began in April 2024. When Trump violated a gag order restricting public commentary about jurors and witnesses, Merchan fined him for contempt and warned that continued violations could lead to incarceration. The judge's message was direct: political stature does not exempt a defendant from courtroom rules. The enforcement of gag orders became a flashpoint, with Trump framing the restrictions as election interference, while the court framed them as necessary to protect the integrity of proceedings. This tension illustrates the larger accountability debate, whether judicial safeguards are neutral protections or political constraints. In Washington, U.S., District Judge Tanya Chutkan faced the complex task of applying the Supreme Court's immunity framework to federal election-related charges. Proceedings slowed as arguments unfolded over which alleged actions fell within official presidential duties. The recalibration did not erase the charges, but it required a granular legal review of presidential conduct, something rarely tested at this scale in American history. Every motion filed under this new immunity doctrine contributes to a growing body of precedent that will influence how future administrations interpret executive protection. Responsibility also extends to prosecutors navigating these legal thresholds. In Georgia, District Attorney Fani Willis overcame a challenge to her role in the state racketeering case, though hearings scrutinizing her conduct added delay and public controversy. The episode highlighted that accountability applies not only to defendants, but also to those bringing charges. Courts are examining conflicts of interest, evidentiary standards, and procedural fairness with heightened sensitivity due to the political stakes. The broader controversy is no longer about individual verdicts. It is about institutional balance. Trial judges are asserting procedural authority. Appellate courts are refining enforcement boundaries. The Supreme Court has expanded presidential immunity while leaving factual determinations to lower courts. Trump continues to denounce rulings as partisan, while courts continue to respond through written opinions grounded in statute and precedent. This reciprocal pressure has transformed the judiciary into a central arena of political conflict. What makes this moment volatile is that no final resolution has arrived. Appeals remain pending, immunity questions are still being litigated, financial judgments are under review. Criminal proceedings continue to unfold. Each ruling either reinforces judicial authority or tests its limits. Accountability is being defined not through rhetoric but through enforceable orders, and the struggle over who ultimately controls the legal narrative is far from settled. The final and most consequential phase of this confrontation between Donald Trump and the judiciary is no longer about individual verdicts. It is about precedent that will outlive every person currently involved. The July 1, 2024 decision by the Supreme Court of the United States in Trump v. United States did more than slow a federal prosecution. It permanently altered the legal architecture surrounding presidential accountability. By establishing absolute immunity for core official acts and presumptive immunity for related conduct, the court created a constitutional shield that future presidents will invoke. Lower courts are now tasked with defining what qualifies as official, meaning trial judges must parse speeches, communications with federal agencies, and interactions with state officials under a new constitutional lens. That process will likely generate appeals that could return to the Supreme Court, meaning the boundaries of executive power remain unsettled and actively evolving. The legal system has not closed this chapter, it has opened a new constitutional era. At the state level, financial enforcement actions continue to shape Trump's legal exposure. The $454 million civil fraud judgment imposed in February 2024 by Justice Arthur Engoron remains under appellate review, but the requirement to secure a $175 million bond in March 2024 underscored that court rulings carry real liquidity consequences even during appeal. If higher courts uphold the bulk of that judgment, it would stand as one of the largest financial penalties ever imposed on a former president. If reduced or overturned, it would fuel arguments that trial courts overreached. Either outcome will influence how aggressively state attorneys general pursue complex financial cases against high-profile political figures in the future. The appellate ruling will not just resolve a dispute. It will signal how far states can go in policing corporate conduct tied to national political actors. The Manhattan criminal case, overseen by Justice Juan Merchan, also carries forward-looking implications. Enforcement of gag orders and contempt fines demonstrated that judges are prepared to regulate courtroom speech, even when defendants are active political candidates. If appellate courts affirm those enforcement measures, it strengthens judicial authority to insulate proceedings from political intimidation. If narrowed, it could expand the latitude of defendants to challenge judicial constraints publicly. That tension between First Amendment protections and fair trial safeguards will likely persist in high-profile cases beyond Trump. Meanwhile, in federal court, U.S. District Judge Tanya Chutkan continues navigating the immunity framework laid down by the Supreme Court. Her rulings on what evidence may proceed under the official acts standard will help define how prosecutors structure future indictments involving executive conduct. Each evidentiary decision becomes a blueprint. The judiciary is not merely reacting, it is building doctrine case by case, motion by motion. Legal scholars are already analyzing how this evolving framework could affect future investigations involving national security decisions, executive communications, or emergency powers invoked by sitting presidents. The broader institutional impact is equally significant. Public trust in the courts has become deeply polarized. Surveys throughout late 2024 reflected stark partisan divides over whether prosecutions represent lawful accountability or political weaponization. That erosion of shared confidence presents a long-term challenge. Courts derive authority not from force but from legitimacy. If large segments of the public reject rulings as partisan, regardless of evidence, the judiciary's stabilizing role weakens. At the same time, failure to enforce the law uniformly would undermine the principle that no individual is above it. The legal system is walking a narrow constitutional line: enforce statutes without appearing political, preserve independence without yielding authority. The trajectory ahead remains uncertain. Appeals are pending. Immunity boundaries are still being litigated. Financial penalties could be affirmed, reduced, or overturned. Additional Supreme Court review is possible. What is clear is that the clash between Trump and the judiciary has evolved into a defining test of separation of powers in the modern era. The question now is not whether the legal system will respond. It already has. The question is how far those responses will reshape executive accountability for decades to come.